Welcome, everyone. We're happy to see everybody today, and we will have three speakers that I will introduce shortly. But I'm also excited to say that we have retirees from UC Berkeley, LBNL, UCOP, UC Riverside, UCSC, UCSF, UC Davis. So with the challenges of COVID, it's allowed us to try new things. And so we've opened this up wider to many UC retirees. And we're glad to have you here today. We also have active employees here today from our affiliates, the lab, LBNL, and OP. I want to welcome my colleagues, Christina Odeji from UC Riverside and Christy Dolly from UC Santa Cruz, also Kyle Urban from UC Davis. Those are our retiree center directors that helped us get this out to other retirees. Today, if you have questions, we'll be taking, I see our people are already putting questions in today's, in the chat window. If you have a question, you can put this in the chat window. We'll be opening up for about 5 to 8 minutes after each speaker to answer questions. And then we'll also have time for questions at the end. So I'm pleased to introduce the three speakers today, starting with Kristen Southworth, who will be presenting on estate planning. Kristen received her JD from University of Wisconsin School of Law. And then moved to California in '94, where she is now currently a member of the State Bar of California. She practices at Southworth and Chavez, which is her firm, and focuses on serving the legal needs of families and disabled children and others. Then following Kristen will be Dr. Ryan McMahan, who's a resident physician and primary care doctor at Kaiser, San Francisco, as well as adjunct instructor for the Division of Geriatrics at UCSF. And I met Ryan when I used to work at UCSF in geriatrics, and so I'm so glad we can bring that circle back and have him here today. He's been involved in advanced care planning research over the last 10 years, and he focuses on helping older adults make difficult medical decisions. Then following Dr. McMahan is Don Goldberg. He's a retirement counselor and the customer care supervisor at the UC Retirement Administration Service Center. Don teaches thousands of employees and retirees every year on the ins and outs of the UC retirement plan. And he'll be talking today about the survivor benefit. And I didn't mention earlier that Dr. McMahan will be, of course, talking about the advanced planning part of this presentation. So I will hand it over to Kristen, which I'm going to let me just spotlight her and okay, Kristen, wow. You'll just see yourself and welcome.
A beautiful picture of myself to look at through this presentation. I've never done it this way before.
Yeah.
Well, good morning, everybody. I'm very happy to be here. I've done a number of presentations for Carrie, only normally on campus. So I miss having the actual face-to-face, but this is about as good as it gets right now. Let me just say a couple things. One, because I'm a lawyer, I have to say that by virtue of your presence here and my presence here does not form any attorney-client relationship. This is just for your informational purposes. If you have specific needs or questions, I definitely encourage you to see an attorney. Second, there's a lot of road construction where I am right now, so I am going to apologize in advance if it gets noisy. Hopefully it won't. And finally, you may see a furry head pop up every now and then. My dog Olaf is a constant companion. All right, so without further ado, and hopefully he won't be a vocal companion at any point during the presentation. So what I'm going to do is I'm just going to treat this because I have about 30 minutes as if you were coming into my office and explaining to you how an estate plan might work. Obviously, one part of an estate plan would be an advanced directive, and I'm really looking forward to Ryan's presentation. So I'm not going to cover that at all, but just know that that would be a piece of what we would talk about in my office. Okay, so estate planning, what might you need? Well, first off, everybody needs some sort of plan. But what might you need, and what are the considerations? So estate documents actually focus both what they have a focus and a function while you're alive, and then after you pass away. What we're going to talk about is what documents would be in that little library. First off, a trust. Why might you need a trust? Well, in California, most people have a trust to avoid probate. You do not need to be wealthy to have a trust. And the reason you're trying to avoid probate is, one, it's expensive. And let me just give you an example. So let's just say you have a house that's worth about $1 million. It's going to cost you at a minimum your beneficiaries $25,000 to probate that asset. Okay, because the fees for both your attorney and the executor, if the executor decides to take fees, are fixed by statute. So if for example, in the $1 million house example that I just gave you, the $25,000 is if your executor was a child or a family member who decided to waive their fees. If the executor did not waive their fees, you would be looking at closer to $48,000 to probate your house. So it's expensive and it's time consuming. It usually takes at least a year to wind through the probate process. So many people prefer to have their loved ones avoid that. The way that you do avoid it is with a trust. Now, what might, so that you have in your mind what might trigger probate? Probate is triggered if you have assets that are above about $160,000 that are non-beneficiary designated assets. So if you rent an apartment, but you have a 403B or a 401k or an IRA where the cumulative value is $1 million and you have designated beneficiaries, those assets would not trigger probate because they are beneficiary designated. If you have a house, if you have a straight up investment account, that would trigger probate. And so then we would look at a trust. So let's pretend right now that we've made a decision that you're going to have a trust. The trust functions while you're alive because you're going to fund the trust with assets. So if you come to my office, we titled your house in the name of your trust. We title an investment account in the name of your trust. Those assets are in it while you're alive. You will be the trustee of your trust so long as you have capacity. So you will be managing those assets just as you are now. There would be no change other than the fact that the title would be different. All right. Now, what's nice about this is that if you become incapacitated, your successor trustee can step in and manage those assets for you. And they would be managing them under the terms of the trust. So it's a very seamless transition while you're alive. What happens when you pass away? Your trust tells your beneficiaries who is going to get your estate. And then I'm just going to ask somebody to mute because we're getting started. Awesome. Okay. So your trust then has a successor trustee. And for the lay person, think who you would choose as an executor. That's the person that's going to manage your assets. They're going to distribute your assets after you pass away, and they will distribute it according to the terms of the trust. Now, what are some nice features of a trust? It gives you a little bit more flexibility than just designating a beneficiary. So for example, you could have a straight up investment account, but That straight up, and maybe you make a beneficiary designation to that investment account. You make it a transfer on death. But what that means is on your death, person A gets that money. Whereas in a trust, you have a little bit more flexibility and a little bit more control. So for example, if you have children, we always include a trust for younger beneficiaries, which designates at what age young adults, because it's usually young adults, are going to receive disbursements if you should have an untimely death. So you might say at 25, you get so much, and at 30, you get the remainder. Whereas if it's a straight up transfer on death account, you don't have that kind of flexibility. If you have a beneficiary who has a special need or who develops a special need, we always include flexibility for the trustee of the trust to put in place a special needs trust. Again, that is not present if you're just doing a transfer on death designation person. We also have ability in the trust to say, if I've named person A and they predecease me and I don't remember to take that out of the trust, we have contingency plans. Does it go to their children, maybe your grandchildren? Again, your trust for younger beneficiaries kicks in. Does it go to a charity instead? Does it go to their siblings? So a trust provides a whole host of options for you so that you can decide how you want things, how you want your assets distributed on your death. Some considerations when you make a trust, again, would be, and when you make any estate plan, would be just your basic, what is your life looking like right now? Are you married? Do you have children? Do you have adult children? Are you a blended family? Do you have a special needs beneficiary? So all of those characteristics we would take into account when we're drafting a trust. So that's assuming you need a trust. What goes with a trust? A pour over will. You should never need to use a pour over will if your trust is funded properly. A pour over will comes into play when an asset gets left out of the trust that's more than $160,000 that should have been in the trust. Oftentimes this crops up if you have a trust, your house is titled in the trust, you refinance it. Refi companies frequently ask you to take it out of the trust during the refinance. You get the refi, and then you forget to put it back in the trust. Okay, so that does happen. We do have a little mechanism that might save it and be able to get it back into the trust, but that's often where a pour over will might come into play. While I'm talking about a pour over will and wills in general, one misconception that I find is that people think that if you have a will, that avoids probate. Get that out of your mind. That is not true. A will is part of a probate proceeding, and you could either, there's two ways a judge would know what to do with your estate during a probate proceeding. One is a will, which is very much like a trust. You'd say, I want, my 3 children to split my estate equally. And that's in a will. A judge would follow that. But it means your kids are going through the entire probate process, paying for it, waiting for it. All right. The other way a judge knows how to distribute your estate is if you don't have a will, and it's called dying intestate. That means you don't have a will, you have left no directions as to how your estate is going to be distributed, and the judge distributes it according to law. And that may or may not be how you would want your estate distributed. So I would urge you to either find out what the law is if you don't want to have a will, and determine, is this how I would want my estate distributed or not? So I want to be perfectly clear. If you only have a will and your assets total more than $160,000 and they don't have beneficiary designations, you will go to probate and the judge will distribute your assets according to the terms of your will. Okay? All right. So you have a trust, You have the pour over will, which is a whoops, some mistake happened. I'm still going to tell the judge what I want to have happen. What are assets that are beneficiary designated? Because this is another way to dispose of assets that is outside of a trust and outside of a will. And probably the benefits person is going to talk to you about your 403B, your IRA, your 401k, though life insurance. All of those have beneficiary designations. Now, for life insurance, you could make your trust the beneficiary so that on your death, it all funnels into the trust and that asset is distributed according to the terms of your trust. You can also do that with retirement accounts, although to me that it would be a very limited situation, and I would want to discuss that with a potential client as to why they might want the trust, the beneficiary, as opposed to individual people, because oftentimes an individual is going to have a little bit more latitude and may be able to get more benefit by being an individual getting the 401k or 403b than if it's the trust and it passes through the trust. All right. So those are the documents that determine how your estate is passed on your death. Could be what we call a revocable living trust. That's what I've been talking about. And a will. And beneficiary designated assets. Those are the ways that your assets can pass to your beneficiaries. I want to talk a little bit about a power of attorney, which is a document that functions while you're alive, and it is very important. And sometimes people say, well, if I have a trust, why do I need a power of attorney? Because my assets are in the trust. A trustee or a successor trustee only has power over assets that are actually titled in the trust. So your trustee will have no power over your 403b. They don't have any power over health insurance. They don't have any power over Social Security. So if somebody needs to interact with institutions like Social Security, like a health insurance company where you're trying to arrange payment, and it would be your agent under your power of attorney, your agent under your Advanced Health Care Directive, as the physician is going to discuss, is going to make medical decisions for you. But how those decisions are paid for, that may be your agent under your power of attorney. So it's very important to have a power of attorney in place in case you become incapacitated, especially during this very crazy time of COVID-19. Your agent there's two types of powers of attorney. One takes effect immediately. And sometimes when we have an older client come in and they're feeling like they can't manage their affairs anymore, that's the type of power of attorney that we will execute. One that takes effect right away. The agent starts using it right away. The second type, which is what I draft more frequently, is called a springing power of attorney. What that means is that power of attorney doesn't take effect until a certain event happens, namely your incapacity. So you get to define how incapacity will be determined in your power of attorney. So for example, I think of it as there's two different types of models. It could be that it's your primary care or your treating or any treating physician that you have would write a letter and say, Mary Smith no longer has the ability to manage her financial affairs. And that would conclusively establish under the terms of your power of attorney that your agent needs to start using the power of attorney and managing your affairs. So one is by a doctor or two doctors saying that you have that you do not have capacity. Another model, which might be interested to get Ryan's input on this, is where your family or friends reach out to your physician and maybe voice a concern. Hey, I'm really worried about Mary. I don't think she has the ability to manage her affairs. And then maybe the physician would render an opinion, but maybe not. And I have never had this happen where the family feels that the person can't manage their affairs, but the physician is a little reluctant to do it. In every situation where we've gone to a physician and asked for that type of letter, we've gotten that. But I will say, it's been so patently obvious that a 7-year-old could probably identify that the person couldn't manage their affairs. That is, they've had a catastrophic stroke or something like that. But what's more problematic, and what I've heard other legal practitioners say is, as people age, cognitive impairment may appear differently. The arc may be different. And so somebody may be able to appear relatively competent in their physician's office, but the husband or children knows that that person has a stack of bills sitting on their desk that they haven't paid for 3 months. So sometimes we'll have a list of people, could include the physician, could include a spouse, could include adult children, siblings, best friends, but the list is something that you get to decide. And then you decide, well, it's 2 out of 4 people or 2 out of 5 people. It's not a unanimous vote. It's not a poll. We just pick a number that you're comfortable with. And if those 2 people say you're not managing your affairs anymore, and they write a letter to that effect, again, it conclusively establishes by your wishes that you are not able to manage your affairs, and the agent under your power of attorney steps in and begins managing your affairs. So again, 2 different types, one that takes effect immediately and one that's a springing power of attorney. And again, I would, anybody who does not have a power of attorney, I would urge you to at least get that in place. Now, what are considerations for what I call them, and it's the big bucket of alternate decision makers. It's people who stand in your stead and make decisions for you when you can't. And those people would be your successor trustee, your agent under your power of attorney, your executor under your will, and your agent under your Advanced Health Care Directive. Because the doctor's going to talk about the Advanced Health Care Directive, I'm going to leave that aside, but I am going to say that the skill set for that could be different than the skill set for the other 3. That is your successor trustee, your executor, and your agent under your financial power of attorney. For those 3 documents, you want to consider what skill set is needed. And you need somebody, A, who's going to be responsible, who's going to pay your bills, who's going to deal with the insurance company if there's a copay issue, who's going to deal with Social Security if there is an issue. So it can't be, as some clients will say, oh, so, my artist wacky brother who doesn't like to pay attention to details like that, that's not a good choice. Correct. Much as you love that person, they may not be the right person to fill that job. Okay. So you need to consider who that person is. One thing that I see with families where there are children is often there's a default to the oldest child. The oldest child may not be best suited for that position. One example that I frequently give is it was a woman, she had 3 children. She lived closest to her youngest child, but she had chosen her oldest child to be her agent under power of attorney and successor trustee, and she had had a stroke. Well, it was the youngest child who was trying to manage all of her care. And so what he would have to do is he'd be sitting next to her in the hospital. He'd be on hold with the insurance company. She'd fall asleep while they're on hold. He'd get taken off hold. He'd have to wake his mother up or call back again because he wasn't the person that she had appointed. So I would urge you, when you're making the decision about who you're going to pick as your first in line to make decisions, to think about the mechanics of how that's going to work. So if it's your youngest child and you live near them and they're going to be managing your care, then that may be the person to choose over the oldest child. If you don't have anybody to choose, and I get this quite frequently, maybe your spouse has passed away, maybe your kids live far away, maybe you've always been single and you're not sure who to choose. There are a number of choices. There are professional fiduciaries that will fill that role, whom you can interview. There are okay, you're going to go. There are banks or financial institutions that can fulfill that role. We can talk about a list of friends. So to me, the choice of alternate decision maker is one that really does warrant consideration. Let's say your best choice is somebody who lives far away. That's not fatal to choosing them. Obviously, with online banking and what we're doing right now, there's certainly ways for people who live far away to act as your decision maker. But I will say it is a little bit easier if there is geographical proximity to you. Let me just go over a couple of other documents, and then I'm going to turn it over for a question. Oh, well, I guess one other thing I want to say is, if you have a situation where there's a lot of tension in your family amongst children, making one of those children your successor trustee or your executor could be the recipe for disaster. And so I also urge people to think about their own family dynamic. And is there somebody who can step in and manage it calmly with not much muss or fuss? Or is it going to if there's a lot of sibling tension, is it going to degenerate? And then again, in that case, you may want to choose a neutral. It may save a lot of time, energy, and future hard feelings amongst your children. Couple other documents that just you might want to have in your toolbox are HIPAA waivers. Even though we might include that in the trust, I think it's just as easy to get them signed so that your agent under your healthcare directive and your power of attorney and your successor trustee can get information with respect to capacity. Gift list, we often include those with the trust so that if there's just informal giving that you want to give, that you want to bequest somebody, grandpa's gold watch, we have a gift list that we attach to your trust where you can outline those types of things. So Carrie, I've got like 6 minutes left. Should I open it up for questions right now or keep going? What's the feeling?
Well, we have some questions coming in. Is there any wrap-up point that you?
Well, I guess what I would say, because I think it is important for people to be able to ask specific questions, and I feel like I've given people a lot of information right now, is that it's an important topic. With coronavirus, it is important to have your documents in place because I am restricted in terms of going into assisted living facilities, in terms of going into long-term care facilities, and even hospitals. Before this pandemic hit, so long as somebody had capacity, I could visit them in places like that and get documents done. I can't do that anymore. So I would urge people that if you're feeling well, and especially if you have AROG, which is the legal insurance that UC offers, and I'm going to say it's a very good deal for you. I am one of the providers on that in terms of estate planning. There is no reason not to get your estate plan in place. So that would be my wrap up. And then why don't we go ahead and go to questions?
All right, great. And I'll put the link to AROG. If people don't know what that is, I'll put it in the chat. And we'll also be sending a summary of links to everyone following this session. So I've got a few, I've got a few questions that have already come in. So let me go ahead and read some of those off. So what happens to assets not in the trust, newer assets that haven't been made into the existing irrevocable trust from 20 years ago and you die before updating it?
Yeah, that could be a problem. So you can always, you do not need a lawyer. One thing that we do with our trust is we do a Schedule A, and we outline the initial assets of the trust. And then we also outline assets outside the trust, because it is very, if you went in and were trying to wrap up somebody's affairs, what you would be so grateful for is a comprehensive list of what's out there, so that you're not scrambling, looking through bank statements to see if a bank account is still open. So you can change your Schedule A. You do not need a lawyer to do that. Let's say you bought a vacation property in Tahoe after you did your trust. You can title that property in your trust. It's just a deed. You can come to a lawyer to do that. If you open up a new investment account, you use your certification of trust, which is something we provide. You use your certification of trust to the financial institution to prove that there's a trust. You don't have to show your whole trust, and you title it in the name of the trust. So really, it is up to you, the individual who created the trust, to get your assets in there. The only one I can help you with is the deed to the deed to real property. I can do the deed and send it into the recorder's office, but other assets I can't, because they're not mine. You have to make that contact with your financial institution. Whether a court would put an asset into the trust that you acquired after the trust, that's very iffy, because a court may say, well, you knew you had the trust and you didn't put it in there, so maybe there's a reason you didn't want it in the trust. So if you've got assets sitting out there that aren't in the trust, I recommend getting them in there. They should be in there.
Okay, great, thanks. There's a question about finding reputable, which I've put in the chat box, finding a reputable fiduciary. There's a statewide association for fiduciary planners. I put that in there. And then there was also a question about finding a trustworthy conservator. And I've also put that in here for the California court has a website. But what do you thoughts on that?
Let me just expound on that a little bit, Carrie. Mm-hmm. With respect to conservator, we nominate conservators in our power of attorney. So if you have if it's your agent, we usually nominate your agent that you've identified in your power of attorney to be your conservator. And I'm not sure that was the question. If you're trying to find a conservator for someone else that you think needs a conservator, then they may be appointed by the county. But you, again, this is why I'm urging people to get their documents in place. You can nominate your own conservator in your power of attorney. So you don't have to be looking for somebody. One other thing I want to say about the power of attorney. If your power of attorney is more than 5 to 7 years old, although California does not have a statute that makes them stale or unusable, sometimes your agents are going to get pushback from financial institutions or even Social Security. I just had a financial planner tell me that Social Security is pushing back against any power of attorney that's more than 7 years old that has not been used. So if you have an estate plan in place, take a look at when your documents are executed. Now's the time to update them.
Great. Let me see. Just a phrase explanation. Okay, that's great. That was clarifying the conservator. The link I put in there was just a map that the California state, puts out there about conservatorship. Okay. But phrase explanation: executor for trust, power of attorney for will, agent for healthcare directives. Is that the lineup? Oh,
the phrase.
Yeah.
So the phrases are for your trust. You're the first trustee. So you have a successor trustee. Carry that over. Now we're looking at the will. It's the executor. That's the person who distributes your estate. Carry that over to your power of attorney for finance. It's your agent under your power of attorney. All of those, the way that I think about them, they're alternate decision makers. They speak for you, but those are the terms.
Okay, great. And so I think we talked about, do you need a will and a trust? What's the difference? That's really what you just went over. So there's several more questions I'll go to. Can you make a new power of attorney outside of existing trust? Does that make sense? That question?
Well, the trust and the power of attorney, there's a little bit of overlap, but they kind of cover two different things. So the trustee only has control over assets that are titled in the trust. Yes, of course you can make a power of attorney. You can have both a power of attorney and a trust. And in fact, you should. If you have a trust, you should have a power of attorney, because they do deal with slightly different, as I explained, slightly different things. Your trust is revocable, so long as you didn't do an irrevocable one, but I'd be shocked. Those are very specialized. Your trust is revocable. Your power of attorney is revocable. You can always revoke a current power of attorney. When we do a new one for someone and update it, we just say, I revoke all previous powers of attorney. This is now my power of attorney. But yes, you can have a power, you should have a power of attorney if you also have a trust. Having a trust doesn't negate the need for the power of attorney, if that's the question.
Okay, great. And once again, repeat those phrase explanations. So who does what?
Okay.
Yeah.
We'll go over it. Yeah. So I know it's a lot of terminology, and I'm sure your hair feels like you're flying back, right? So the trustee of a trust manages trust assets. And if it's not you, it's a successor. That's called it. It's just the second in line. Think of it that way. It's the successor trustee. They can only manage trust assets. So if it's an investment account, a straight up investment account, all the trustee can manage is that investment account. If your bank account has $40,000 and it's outside the trust, your trustee has no power over it. None, because it's not titled in the trust. Who might have power over it? Your agent under your power of attorney. Your agent under your power of attorney has the ability to manage, if it's financial, manage accounts that are not inside the trust. They also have the ability to deal with government entities for purposes of public benefits, and the ability to talk to your health insurer. So it's your agent under your power of attorney that is going to do those tasks. Your executor, that only comes into play after you've died and if you need a probate. Then your executor is the person who is going to be the point person distributing the contents of your estate after a judge tells them it's okay to do so. Okay?
Great. I think this clarifies, again, this is a question we get about trust. Are trusts really necessary unless one has a large sum of money in their estate?
Yeah, the thing is a large sum of, if you have a house or a condo, you're going to probate that. So the trust, it's a vehicle to avoid probate. The only way you avoid probate if you have $160,000 or more of assets is if every single one of them is beneficiary designated. That's the only way you avoid it. Otherwise, if you get an aggregate, let's say you have an account in one bank that's $30,000, you have an account in another bank that's $30,000, and you have a condo, and you don't have a trust, you're going to go to probate. Your heirs are going to go to probate.
Okay. And so what I'm going to do is I'm going to put the remaining questions, Kristen, to you by email or by once I'll repeat them in the chat, and then you can answer them one by one while we're maybe moving on to the next one, or we're going to, or you can do them afterwards as well. And then I'll just one last, just the approximate cost of attorney fees for a new trust.
It depends on if you have AROG or not.
Yeah.
If you have AROG and you're a UC employee, generally, I can't guarantee it for all UC employees, but for most of the people that I do with UC, the cost is nothing to you other than recording the deed and notary fees. So if that's why it's such a good deal. If you don't have ROG, they can be, I mean, it depends on how complicated it is. There's a lot of flat fees, for an attorney. I would say it could be anywhere from, $2,000 to $7,000 or $8,000.
That's right. And I can attest to AROG, everyone. That is your benefit, that if you don't have it already, it will be available, should be available during open enrollment. It's not always open, but it has been for the past several years, and it's available to retirees too. I can't answer specific questions about AROG, ARAG, but I will send a link afterwards, and there's been one in the chat box. And there was a question here about advice in Washington, but Kristen, I think, how would someone in another state go about finding helpful information specific to their state?
If you live in Washington, then you really do need a Washington attorney. And if you have ROG, they are nationwide. You may be able to find one there. Otherwise, I call the local bar association and get a list of people. Or honestly, I've had clients come in because somebody's recommended me on Nextdoor. So that's as good a source as any. But now, I just want to say, if you have a California trust and you've moved up to Washington, that doesn't necessarily mean that your trust is no good anymore. You just have to figure out, if you bought a house or a place up there, should it be titled in your trust, or is probate different in the state of Washington and it's easier to go through probate?
Okay, great. And I'll put these other questions, I'll have them populate in here and you can take a look at them. Kristen, I'll just send them to everybody. And UC does not, Don says here that AROG is open this year for open enrollment. UC does not provide full estate and will planning. That was one question that we got. But the AROG benefit does serve as that. So, all right. So, thank you, Kristen. I always learn something new, and it's helpful. I'm going to take you off spotlight now so you can see all the great people here today. And I'm going to pass it on now to Dr. McMahan. I'm going to just go ahead and let you share your screen. What we'll do is we'll have questions after each one, and then we'll have enough time for questions following as well.
All right, so I'm hoping everybody can see my slides by now, which I'm pretty sure we test run this, so it should be working. So yeah, just again, to introduce myself, I'm Dr. McMahan. I'm a resident physician at Kaiser San Francisco. I also do some primary care there. And then I'm an adjunct instructor at the Division of Geriatrics at UCSF, where I've worked for quite some time. So first off, thanks for inviting me here. Really excited to talk to everybody. Primarily, congratulations on retiring. I'm pretty early on in my career, so I'm very jealous. I hope to get to where you all are someday soon. And then also congratulations on kind of taking these steps to prepare as best you can for your later years. And so that's part of what the next couple of slides are going to be about. So I have some goals for today, essentially just defining what we mean when we say advanced care planning, kind of what it is and what it is not. I figured I could give some examples of how advanced care planning is used in hospital settings, talk a little bit about advanced care planning in this era of COVID-19, and then share some tools to help you get started and hopefully have some room for questions at the end. So first off, what is advanced care planning? There is an official definition. So when we say advanced care planning, we mean a process. So not just a one-time event, but a process that will support adults really at any age and any stage of health in understanding and sharing their personal values, their life goals, and their preferences regarding current and future medical care. And so that's, of course, a mouthful. Interestingly, there really wasn't a global definition for advanced care planning until recently. Our research team got a group of experts together to kind of create this definition, because before people were using all kinds of different concepts to mean advanced care planning. Is it just a document, or is it a bigger process than that? And so this is what happens when you get a group of experts together to create a definition, which means it's very long and has a lot of different components to it. But the main goal here is, let's help people get the medical care that's consistent with their values, goals, and preferences during serious and chronic illness. And so that's sort of the main point of advanced care planning. And so kind of what it is and what it is not, as we mentioned, it's a process, not a one-time event. It's ongoing. It's going to continue as you age and as your health changes. It's also your legal right to talk to your doctors about what your preferences are for your medical care. And then what it's not, it's not just an advanced directive, but it also includes discussions with your doctors, your family, and your friends. It's also not just for the sick, but it's really for everyone. And it's especially important to do while you're still healthy. It's also not just for you, but it's for your family, friends, and your care providers. In fact, one of my patients recently described their doing advanced care planning as they're trying to give a gift to their family. And I thought that was a very nice way of sort of describing this process. So I did say the word advanced directive. So what is that? It's a legal document that you fill out, sometimes called a living will. And its main job is really to designate a surrogate decision maker, which as we just heard about, we've heard about this term, a durable power of attorney, and this is the durable power of attorney for healthcare. In the rest of the slide, I'll call them a surrogate decision maker. You'll also hear a proxy decision maker. It's essentially someone in your life who you trust to make medical decisions for you if you're unable to speak for yourself. So that's what we mean by decision maker. And the advanced directive has its main job of documenting who this person is. And it also is designed to designate your treatment preferences for your medical care. Sometimes it's something very specific, like life-sustaining treatment options. So that's things like, do you want CPR? Do you want intubation? Or would you want feeding tubes? But other times it's more global goals for your care. Sometimes people have strong preferences about living as long as possible, being as free from pain as possible, being able to interact with family and friends. Of course, we would hopefully choose all of those options for our goals as we age and continue to live into our later years. But of course, as our health changes, sometimes we weigh those things differently. And so the advanced directive can help kind of specify where you put that weight. And so why should you do advanced care planning? Well, research has shown it's improved patient satisfaction with their medical care. It's improved some people's quality of life when they do it and when it's done properly. It has been shown to lead to less unwanted medical care. And it also has provided less stress for your surrogate decision makers and families. When we do focus groups with older adults and people who've kind of gone through this process and kind of come from on the other side of big medical decisions, or when we've spoken with families of older adults who've kind of gone through this process, something we hear all the time is that, they don't want to be a burden. And this concept of burden is heard kind of throughout advanced care planning research. And sometimes it's burden from caregiving, which is a common concept, but also this acknowledgement of an emotional burden of decision-making that happens to our family and our friends as we age. And so advanced care planning is really one way to help mitigate this process. Of course, it can never take away the uncertainty that can happen towards the end of life and with serious illness, but it's at least one tool we have to help mitigate that. So another reason to do advanced care planning, interestingly, only about 1/3 of older adults actually engage in advanced care planning, and that's been the same for over the last 10 years. And it's an interesting statistic because close to 70% of older adults, when they're getting to the end of life, are unable to make their own decisions. And so there's a pretty big disparity here where we know a large group of people might get to this point, but an equally large group of people haven't really prepared for that. We also know that there's been lower engagement in racial and ethnic minorities and populations with regards to engaging in advanced care planning. Only about 20% from these populations do that. And that could be for a number of reasons, from access to medical care, outreach from healthcare institutions, language or cultural concordance in regards to different values for advanced care planning. Of course, racism in medicine exists as well. So we need to do better there in terms of reaching out to these populations. Also, about 20% of older adults have discussed their wishes with their medical provider, which is surprisingly low. And among people who die in the intensive care unit, about 20% of them have no advanced care planning in their chart at all. So really a missed opportunity for people who have serious illness to discuss their wishes with their doctors. And then advanced care planning is especially important now in this era of COVID-19. We know COVID affects people of all ages. We also know that people with COVID can have very unpredictable courses. They can worsen very quickly. A number of patients I've had that are speaking to me, one day and they seem to be doing okay, and the next day maybe they're intubated and I can no longer communicate with them. So things can change quickly. As Kristen Southworth had mentioned too, there's no visitor policies right now in all hospitals, emergency rooms, and nursing homes. So it's really hard to get people who might know these people best at the bedside to help with decision making. Also, things happen quickly, and sometimes people can come in without things like hearing aids, eyeglasses, cell phone chargers. And so again, this limitation on effective communication is very real in COVID-19 times. And then as a frontline provider, we are desperate to know any information about people and their family contacts when they get so sick that they can't speak for themselves. So again, advanced care planning is a great way to kind of try to mitigate some of these unique experiences during COVID. And so I figured I'd share a clinical story about how advanced care planning can be used in the hospital. I did change some details, of course, just for privacy, but in general, this is a very common story and is pretty close to what actually happened when I was recently in the ICU. So I was working in the ICU. We had an 85-year-old woman who came in with COVID-19. She was very confused and we weren't able to communicate with her. Interestingly, she had a previous advanced directive in her medical chart that stated she was do not resuscitate and do not intubate, and she had a current diagnosis of cancer. That document was about 5 years old by the time that we saw it. Her oxygen status actually worsened. There was a question about what we were going to be doing next, and we called the family immediately to discuss with them about how things have changed. So her family had actually had a very recent conversation with her about her goals if she were to get COVID. And she had said very clearly if she got COVID, she would want to try intubation if it came to that. And then after a few days, we talked to the family, we got their permission to move forward. She was intubated. Eventually her kidneys started to fail as well. And the family kind of agreed that at this point, we were sort of beyond what her stated goals were. They wanted us to focus on making her comfortable and allowing a natural death. So a very sad story, unfortunately, a very common story sometimes in this era of COVID-19, but it does highlight a couple interesting things about advanced care planning. So first of all, she had a DNI order, she had an advanced directive, but she got intubated. Does that mean that advanced care planning failed? Was a law broken that, that we ended up doing this thing that was against what was written down a few years ago? Well, not really, because we were speaking with the family who knew her best and had this very recent conversation with them, so we were comfortable moving forward. And it just highlights this point that it's not always about the document when it comes to advanced care planning. It's about the preparation that you give your family about what your wishes are. So the family, through their own conversations with their mother, they were able to provide important information to us as the care team about the choices their mother would be making for herself if she were able to make them. And that's an important point about choosing a decision maker. You're not necessarily giving them the entire burden of making all the decisions, but you're hoping that they'd be able to make decisions that you would make for yourself. And then through conversations with family and the providers, we're really able to assess these patients' goals and then provide recommendations that were in line with the patient's goals. So that's one sort of common clinical story that I think highlights interesting things about advanced care planning. One other story that I wanted to highlight was just recently in my primary care clinic, there was a 57-year-old Muni bus driver who came in and he had high blood pressure. After trying some recent lifestyle changes, his blood pressure was still high and we wanted to start a new medication. And he had asked me about the risks and benefits about starting a new blood pressure medication. So we had heard that, going to the bathroom more was a common side effect of one of the medications I was recommending. He kind of told me that's not going to fly and that it wasn't going to work given his job. And so we chose a different medication that didn't have that effect. And so is this advanced care planning? So my point is that yes, it is advanced care planning. Knowing the patient's goals, I was able to make a better recommendation to him. The patient was able to get care he wanted using what was most important to him. And so again, this is the kind of takeaway about advanced care planning. It can be about current or future decisions. It covers a range of medical decisions, from big decisions to little decisions. Not that choosing a blood pressure medication is a little decision, but I'm just trying to highlight that there's different types of decisions to be made. But really the key to advanced care planning was better communication and sharing of goals. And I think that was the main points of kind of both of these stories. So hopefully now I've convinced you all that advanced care planning is super important and really great. And so how can we get started? And so I'm a big proponent of the website prepareforyourcare.org. It's an online advanced care planning program that's both in English and in Spanish. You'll be seeing this website, quite a few times in my next couple slides, so don't feel like you have to write it down immediately, and we'll probably be sending this link out later as well. But this is a program that I was involved with both as a research assistant, as a medical student, and then now as a doctor as well. So I've been pretty close to the team who's created this. And so Prepare for Your Care, it's this program that can help you make your medical decisions for yourself and also for others. If you have people in your life that maybe you're the decision maker for, it can help you talk with your doctors and get the right medical care that's right for you. It has this kind of 5-step plan. Also, it asks you specific questions about your values and goals kind of throughout the program, and creates a summary of your wishes, and can also auto-populate an advanced directive at the end, or just allow you to print out an advanced directive to fill out to give to your provider. So when we talk about the Prepare program and really advanced care planning in general, there's kind of 5 big steps to it. The first one, choosing a medical decision maker or a healthcare proxy or a durable power of attorney for healthcare. And it's important to choose this person carefully. I think oftentimes some people will immediately choose, their spouse, but at this moment they're both relatively young and healthy. But then of course, as we age, our partner's health changes too. And so it's not uncommon that maybe, 10, 20 years later, after someone has chosen their spouse as their decision maker, I'm speaking to them and maybe their health has changed drastically as well. And maybe they have cognitive impairment themselves that makes it difficult to have them be an effective decision maker. So again, this idea of it being a process and evaluating it over time is pretty important. You can also always choose a secondary decision maker. Maybe spouse would be number 1, child would be number 2. Of course, not everybody has the people in their life who they trust. And so as Kristen Southworth had mentioned too, not everybody has somebody. And so we kind of talked about the options that we can explore if that is the case, but oftentimes it can be friends, it can be neighbors. The only person it can't be is someone on your medical team. You'd also mentioned, Kristen Southworth, about the frequency of choosing the older child, which is so common. I see that all the time. And whether it's a cultural issue or not, it's just something that happens. And the other side of it is it's oftentimes the youngest sibling that's taking care of the older adult that might even know them best, but then it's the older child that's listed as the document. And they sort of aren't as aware of what's going on with the older adult. And that's a very common issue. Okay, and so besides, choosing a medical decision maker and deciding what is most important in your life, there's also this concept of flexibility. And I kind of highlighted that a little bit in the first example, that even though something was written down on a document, the decision makers really had the flexibility to incorporate what they knew of their mother into a new situation that they hadn't really considered when they filled out this document. And so there's some flexibility there that you can actually decide how much flexibility someone can have in interpreting your values, whether you want them to follow the letter of the document as closely as possible, or if you want them to make the best decision that they believe is right in that moment. And then of course, it's not just about filling out a document and turning it in, but you actually have to tell people about your wishes and who you've chosen. It's so common also for me to, read that it's, so-and-so is listed as the decision maker. I give them a call and they're like, what? Like I was put down on some form. Like, I don't know what they would want. I've never heard about this. I don't feel comfortable making decisions. And so that's a real missed opportunity to have those conversations with someone who you're, essentially saying can make medical decisions for you at some point. And then of course, asking your doctors the right questions is an important component of advanced care planning to make sure that you're getting the care that you want. So those are sort of the 5 big steps, and the Prepare program will walk you through each one. We designed this program actually with input from very diverse populations. We had many focus groups, some specific to certain cultural backgrounds, to certain language backgrounds. Overall, the program is very easy to understand. There's voiceovers of all the text, there's closed captioning, it's in English and Spanish. You can actually choose just to play the website as a video if you don't want to click through everything, and you can just watch the content that way. There's a range of stories from different people from different backgrounds, and they actually just give you the like modeling behaviors. They show you the words you can use for these types of conversations. Might not be the exact script that you're going to use, but at least can give you an idea of how to talk to people about these issues. And so there's some videos of how to talk to someone about being your decision maker, how to talk to your family about what your wishes are. And then again, I mentioned at the very end of it, you kind of create the summary of your wishes, which tells you the decisions you made after each step. And then you have the opportunity to fill out the advanced directive. And so I figured, we have a couple more minutes to kind of dive in a little bit deeper to the advanced directive. This one in particular is the one that our research team made. It's the California Health Care Directive. It's the official advanced directive of San Francisco General Hospital. It's used in many other health institutions, and it's free to download at the prepareforyourcare.org website. And it's used many, many different places. However, your lawyer might have their own advanced directive that they like to use. Your health system might have their own advanced directive that they like to use. But really, all these documents are created for you to, state who your decision maker is, what your wishes are, sign it, and turn it in. And so health systems will accept all kinds of advanced directives. Sort of as an aside, interestingly, advanced directives kind of came about in the maybe like 1990s or so with a law that was passed about the Patient Self-Determination Act, which stated hospitals had to abide by patients' wishes, and so that's how advanced directives kind of became so popular. And of course, in the very beginning, these were documents that were decided upon by a bunch of doctors and lawyers. So you can imagine, the language and the literacy level of these documents was very high, and so the ability to kind of take this very legalese medical language document and interpret it at a bedside for a patient for a decision was very difficult. But they really evolved over the last 10 years or so. And so I think this document in particular is particularly easy to use and very clear, and even allows you to write in some of your own wishes rather than having a checkbox approach that might not fit your specific needs. So diving in a little bit deeper to the advanced directive, the first part, as we mentioned, is choosing who your decision maker will be, who is your proxy, who is your durable power of attorney for healthcare. This person needs to be 18 years of age. Hopefully you'll be talking to them about your wishes, can be there for you when you need them, someone who you trust to follow your wishes or do what is best for you, and someone who you trust to know your medical information and is really not afraid to ask doctors questions or speak up for your wishes. And so when you're listing someone, you can list a first person and also an alternate person. You can also choose when you want them to make decisions for you. Do you want them to make decisions for you right now, or only after you're unable to make your own decisions? And you can also explain sort of when that would be and what those circumstances are. And then, as I highlighted kind of in that first story, this idea of flexibility and decision-making, you can also, in this particular document, talk about how much flexibility you would want someone to have. I think a really interesting story that my main mentor and the person who actually created this website, Dr. Sidori, she tells this story often. It's a story of her own grandparents who, she's an advanced care planning expert. She's a geriatrician. She knows how to do this. And she was talking to her grandparents about their wishes. And her grandfather had said, under no circumstance would he want to be intubated or put in the ICU. And she turned to her grandmother and said, oh, would you make this decision if the doctors were recommending it? And she said, of course I would. Like, I wouldn't be able to say no. And so the real, disconcordance in terms of what the grandfather stated he wanted and what the grandmother said she would be able to do. And when she turned back to the grandfather to say, well, do you still want her to be your decision maker if she's saying she might not even follow your wishes? The grandfather at that point said, well, she's the one that needs to live with these decisions after I'm gone. And so whatever she needs to do to feel comfortable moving forward, that's what I want for her, even if it's against my own wishes. So again, it's this concept of flexibility and how important that is to us, and sort of what our actual goals are for our future care. So I think that's an important point. And then deciding what matters most in life, it's kind of a strange phrase. It's sort of hard to know what that really means. And this advanced directive sort of allows you to kind of place yourself on this scale. And so, we can think about in your current health, how do you want to balance living as long as possible with just focusing on quality of life? Because they can be sometimes at odds with each other. And then you can decide later at the end of life, if things were, if you were to get so sick that you might die very soon, where does that balance go at that point? And so really being able to kind of delineate where you place your value, it's very different for different people. And you might be surprised to hear how people, make these decisions, but it's very individual. Let's see. And then of course, it is a legal document, so you do need to have it witnessed by two people. Or if you don't have it witnessed by two people, you can take it to a notary. And there's certain rules for, what that has to be for this to be an official legal document. And then, we want to do evidence-based medicine. This program, Prepare for Your Care, has been very well studied. There was about 1,400 participants in this study. It was published in JAMA. There was both English and Spanish-speaking participants who went through this website. And 98% of people who went through the website did some form of advanced care planning after going through it. And then it also increased documentation of advanced directives and discussions in the medical record from 8.5% before the study to 43%. So this program really does work. So my main takeaways about advanced care planning is that it's a process. It's not just a document, but it's about these discussions also. It can hopefully help you define what your own values are for healthcare, and it can help start important conversations between you, your family, and your doctors. It also can be done in steps. So you might not be ready to do one thing, but maybe you can tackle another. So I think that's probably the most important thing to think about as we're going through this process. So some next steps, we can think about some homework for everybody. I think today, hopefully, you'll be thinking about who you can choose in your life to be your decision maker, and also maybe who would be, part of your trust as well. That seems like hopefully that's on everybody's minds as we're thinking about this, webinar today. And then hopefully this week, maybe try going to prepareforyourcare.org. Try out the website, click around, see what, jives with you and what doesn't. This month, maybe start the process. Talk to your family, talk to your doctors about what your wishes would be and how you can fill out these documents and turn them in. And then at your next doctor's visit, you can either turn in the prepared advanced directive that's all completed, or just talk to them about what their process is and what documents they'd like to use. And then I'll essentially just end there and just thank, UC Berkeley Retirement Center, of course, for inviting me here and having this topic for everybody. Special thanks to the Prepare team, which I've been a part of for quite some time now, and Dr. Sidori, who created it, and then I shamelessly stole several of her slides as well. And then that's my name and my Twitter handle, as long as email. If you guys have questions after, I'd be happy to answer them. And then we'll be sending out the link for the Prepare website as well after the show, if you will. So I'll go ahead and stop sharing my screen here and maybe have some time for questions.
Great. Thank you, Dr. McMahan. Yes, we have lots of good questions and a comment about how daunting those forms can be and how doable this Prepare for Your Care looks like. Looks to be so easy.
Mm-hmm.
So let me just, let's see here. All right, cancel the spotlight so everybody can see everybody if they want to. So the first question is, in Kaiser, the advanced care planning document, there seems to be an either or about resuscitation in the hospital. I've had medical personnel challenge my directive, but I feel I'm not given a nuanced choice.
I love that you pointed that out, because I'm actually a big proponent of trying to work with Kaiser to improve some of their advanced care planning documents. I agree they have a different approach, I would say, but I would say outside of they call it their life care plan, and they have their own documents that they like to use. But if you do like the way the Prepare program spells things out, and if that kind of jives more with what your own values are, you can absolutely print those out, and it's a legal document that Kaiser will recognize. So even if you might feel like they're trying to put you into a box, but you don't quite fit in that box, it's okay to point that out and use a different document.
Great. Do the DNR, do not resuscitate documents need to be updated?
That's a great point, similar to what Kristen Southworth had mentioned too. These documents, they don't necessarily expire. Once they are signed in your medical record, it's a legal document that will stay there. But anecdotally, just as a doctor, if I see a document that's maybe 10 years old, and you were in a very different health context when you created that document, I might have more questions for the decision maker and the family on how to interpret those values from a decade ago when maybe your health was very different than where things are now. And so that's still why we work with whoever you've chosen as your decision maker, and why choosing flexibility is so important, because maybe in 10 years from now, those decisions that you were so strongly, had feelings for are in a very different context now. So they don't necessarily expire, but I would say, every 10 years people get colonoscopies. Maybe that's also time to update the Advanced Directive. Or when you get a new diagnosis, or when something changes with the health of a loved one, or something like that kind of, especially now, even COVID-19, I've had people in my clinic who say, oh, since COVID happened, I've been thinking about these things. I want to update my documents. So it's a process that happens over time, and you sort of reevaluate things at different moments in your life, but it doesn't necessarily expire.
Okay, great. And there were a couple more Kaiser clarifications. If they wanted to find their one on file, where can they find it? If it's still something you want to do, the Kaiser specific one, you want to
kp.org or My Doctor Online, that's Kaiser's online website. There is a section for documents. There's also a section for life care plan as well, and they should be in there. If you can't find it, send an email to your doctor to say, hey, what do you have on file, and can you send it to me? I want to review it.
Okay, great. Is Prepare for Your Care California specific?
So we worked really hard with all 50 states to create different advanced directives that are in line with each state's rules. So as you can imagine, every state has different legal requirements for their advanced directives. And so with Prepare for Your Care, when you're choosing the advanced directive, you can actually choose what state you're in, and it will populate the document that's legally recognized in that state.
Okay, great. Where does HIPAA release fit into all of this?
So it's a good question. I think HIPAA release is, an important part of the estate planning. Maybe Kristen Southworth can also chime in there. In terms of your advanced directive, you're putting all your information that you want people to know on that form. It's sort of the purpose of it. And so it's not necessarily HIPAA covered, I guess, is the point I would make, is that you would be able to make copies of this form and give it to your family members or whoever you would want to know what your medical wishes are. But getting a HIPAA release is more from the other legal side of things, to make sure that people can, get your health information if they need it. But if you do have, go ahead, Kristen.
Yeah, I was going to say, Ryan, if you want me to chime in, right? I just had a client who's he was agent under, only son. It was his mother, agent under her medical power of attorney, but the hospital was giving pushback about giving documents to him without a HIPAA waiver. So we ended up being able to do one for her, but they are important. It's really just a prophylactic.
Yeah.
Well, that's the same line, Kristen. Just after making a new advanced directive, does it need to be included in an existing trust or kept as a standalone document?
We do it as a standalone document. Sometimes in trusts, they include a HIPAA waiver, but then you have to get your trust out to take to the doctor or hospital. So we do a standalone document that covers the agent under the health directive, and then a second one that covers the agent under your power of attorney or your trust.
Okay, great.
Maybe even actually jumping off of that too, something I don't think a lot of people realize is you might go through all these steps of filling out an advanced directive with your doctor and your health system. Maybe you live in Oakland, but you get all your care at UCSF in San Francisco, and UCSF has all your documents. But maybe if if you have a slip and fall, if you're found down at home and you go to Highland and they don't have any of your documents for you there, then sort of how does anybody know what's happening? And that's why it's so important to talk to your family and have them have copies of these documents too.
Yes, and that is, these two questions roll onto that. If your medical decision maker doesn't feel comfortable taking on the role, can they assign and turn that role over to someone else? How would you respond to that?
So I would say legally, no. You need to have them on the form, which is why it's so important to get people on board early and then say, hey, I'm writing you down here. Are you okay with this? Let's talk about what would happen. And then also, listing a secondary person is also available on these forms. So maybe if the first person in the moment is suddenly actually, I can't do this, there can be an alternate decision maker that will make decisions at that point.
And so how would a lay person learn more about this complicated decision making? If they say the pros and cons of feeding tubes, intubation, et cetera.
I think that's the great point of when you can actually talk to your doctor and ask questions, because that's going to be a different answer for each person, given their different health context. Maybe for you, somebody who might, in your certain health context, intubation, you'd be able to, come out on the other end just fine. If you needed CPR, it'd be just fine. Other people who had different comorbidities or different illnesses could have a very different health outcome. And so that's where partnering with your doctors about these things would be very important to ask those questions.
Great. And one more is, what does the medical language mean, a natural death? Does that mean no water, no food, or morphine, question mark?
So the term allow a natural death means that if your heart were to stop, we wouldn't do chest compressions. We wouldn't use shocks to restart it. Or if you were to stop breathing, we wouldn't put a tube in your throat to help you breathe. We would sort of we would notice that this process of death is happening, and we would support you in those moments in terms of making you comfortable. So that could mean giving you fluids if it was making you more comfortable. It could mean making sure that you are relieved from pain by giving you morphine or other pain medications as well. So it doesn't mean no care is happening. It just means the focus of our care is on your comfort.
Great. Okay, well, Ryan and Kristen, if you'll stick around for the end of the session, we'll leave time for more questions. Thank you so much, Dr. McMahan. This has been, as a gerontologist, just a reminder about how important those conversations are really with your family and your friends. I know we haven't let room for a bio break, but maybe we're going to move on to Don now, and so we'll have time for questions. But we'll record this if you need to step away for a second. Go for it, Don.
Good morning. Can everybody, Carrie, can you see my screen?
Yes, you can see your screen.
Okay.
And I'm going to spotlight your video. There we go. So we just see you. Okay.
Okay, thank you very much, Carrie. Good morning, everyone. My name is Don Goldberg. I'm with Retirement Administration Service Center. Today I'm going to talk survivor benefits available to you. And we're going to talk a little bit about this.
So Don, your video you're lagging a little bit. So if you'll turn your video off, there we go. That should improve your sound.
Oh, okay, good.
There we go. Thank you.
Okay, so the first thing we're going to talk about is payment continuation after death. We're going to talk about the post-retirement survivor continuance. This is available to eligible survivors as defined by the plan for 76 tier members and safety tier members. To be in the 1976 tier, you have to be hired before July 1st, 2013. Then we're going to talk about the alternate payment to contingent annuitant, and that is available for all retirement tiers and where you can name anybody you wish. This one is done at the time of retirement. The post-retirement survivor continuance is dictated by the plan. And then we have pre-retirement survivor income, very, very rare for the most part. And with pre-retirement survivor income, benefits to eligibility for retirement. So the first one is post-retirement survivor continuance. This is dictated by the plan. You do not choose who your survivors are. This is a certain amount that is built into the program. If you chose the basic retirement income, no deduction to your retirement income. If you pass away, your eligible survivor would receive 25% of your basic retirement income if you are coordinated with Social Security. Coordinated with Social Security means that you're paying into Social Security. If you were hired after 1976 and you are not a safety tier member, firefighter, or police officer, you are coordinated with Social Security. If you are not coordinated with Social Security, then your eligible survivor would receive 50%. This provision is only available to 1976 tier and safety tier members. So this is something that you do not decide. The plan dictates if you have an eligible survivor or not. Now you may ask, who are eligible survivors? Well, first it goes in this order: to spouse or domestic partners, as long as you were married or partnered 1 year prior to the retirement and you remain married or partnered. Next, it would go to children if they are under the age of 18 or 22, if they're a full-time student, or a child could be an adult disabled dependent. They can also be an eligible survivor as long as they were disabled prior to age 22, if they were a full-time student. And then the last category of eligible survivors are dependent parents. For a parent to be an eligible survivor, they must be living with you and they must be your tax dependent. So it goes in the order of spouse, domestic partner, children, dependent parents. If you do not have any of the above, then you do not have an eligible survivor. We cannot change the order. You may love the children more than the spouse or domestic partner, but we cannot change the order in which this is paid out. At the time of retirement, we're going to ask you, want to name an annuitant.
Hey, Don, your audio is breaking up. Why don't you can you use your slides on your own and maybe unshare them? Maybe it's slagging down the presentation, and we can send these out afterwards.
Okay, so get rid of the slides?
Yeah, and maybe just have your talking. It's a little slow, so let's try again. Go ahead and try again.
Yeah, because I don't know, how the slides on the screen would affect my audio.
Yeah, okay.
So hopefully this is a little bit better. In this screen here, this is just a example of when you retire. If you are already retired, you already made these choices. If you are still an active employee, this is a choice that you will have to make. And this is just showing you how the options work. So if we go from left to right, we have the monthly retirement options, the basic retirement income option, and options A through D. In this case, the person named contingent annuitant is a spouse or domestic partner. Then the next one is lifetime monthly payment to you, and that is you, the UC retiree. This person is coordinated with Social Security, hired before July 1st, 2013, so their eligible survivor would receive 25% if they passed away. In this case, they are naming their contingent annuitant, so we have options A through D, and then the category on the right is the combined benefit. So when you retire, you have this choice to make. If a person would have chose the basic retirement income, then they would receive X amount of dollars, in this case, $24.33. If they pass away first, their eligible survivor would receive $608. Then there is option A. Instead of getting $24.33 per month, they will take a reduced income. And what will happen is if they pass away, their eligible survivor, which in this case is their spouse or domestic partner, would receive both the $608 and the $1611. So they would receive $2219. This typically is the hardest decision we make in the retirement process. Most people know if they're going to take a monthly benefit or a lump sum, but which monthly income option they'll take is a very, very hard decision for the most part, because if they take a reduction in income, in this case, we'll say example A, they're going to have a reduction of $200 and change. These deductions can be very big. I've had a deduction of $6,000 where a person named a child, in this case, it was an adult child, who was age 35, but they had a reduction of $6,000 per month. So one of the things to consider too is you take this reduction, this person will get an increased benefit for the rest of their life. However, if this person passes away first, you then are stuck with the lower amount. You are taking a reduction. It is a irrevocable decision. So instead of getting the 2433 in this case, you are going to receive the 2219. And again, what you want to do is go to UC Raise, and at UC Raise, you can prepare your own retirement estimate, and you could put in your spouse, domestic partner, or whoever it is you wish to name, and you could see these examples. This again is a fictitious example. Basically, the more money you leave for your contingent annuitant, the more your reduction will be. The amount of your reduction will be based on your age, the age of the contingent annuitant, and the option you choose. If the contingent annuitant is much younger than you, then you would see a much greater reduction based on actuarial lifespans. Next example is very similar to the other one, but in this case, there is no eligible survivor amount. They're either in the 2013, 2016, or they do not have a spouse, domestic partner, eligible children, or dependent parents. So if they chose the basic retirement income, there would be no money that would be paid out to their, in this case, no eligible survivors. They did not name a contingent annuitant. Their UC retirement plan would end. If they chose an option A and named a person a contingent annuitant again can be anyone. So they named somebody, in this case, contingent annuitant, and instead of getting $2,400 and change, they're receiving $2,100, almost a $300 deduction. If they pass away first, their contingent annuitant would receive lifetime benefit of $2,148. If that contingent annuitant passed away first, they're still stuck receiving the $2,148 because this is an irrevocable decision. So very, very important decision. And that is something that I typically tell people that it is good to, if you have not already done this, speak to a fidelity planning and guidance consultant, because they could help you create a financial plan, which would make making this type of decision easier. So next, we're going to talk about pre-retirement survivor income. What that is basically you have not retired and something happened to you pretty much all of a sudden, because we do have a lot of cases where, and I know I've answered these phone calls where people would call me up telling me that they are terminally ill and they want to do the following retirement. So this is a case somebody did not retire and they were eligible to retire, death while eligible to retire. Now, eligible to retire means they have at least 5 years of service and they are age 50. So death while eligible to retire, what happens is if a member passed away, we would say June 15th, UC would retire them the next day as of June 16th, and their spouse or domestic partner would get option A. I'm going to go back a couple screens, and option A is the greatest benefit available. So when you go through retirement and you want to leave the most money for your spouse or domestic partner, you are going to choose option A. So if you pass away while eligible to retire, your spouse or domestic partner will get option A. And I think this is what I would call very good peace of mind, because we do have a lot of employees who worked here many, many years, and they wonder, if I pass away all of a sudden, what would happen? Am I disadvantaging my spouse or domestic partner by continuing to work and not choosing the highest benefit available? If you do pass away all of a sudden and you are eligible to retire, your spouse or domestic partner would get the highest benefit available, option A. Then we got pre-retirement survivor income. This is, I'm going to say, a little bit rare. Pre-retirement means they're not age 50, they haven't reached the retirement age, or for that matter, they have not reached 5 years of service. They have to have a minimum of 2 years. So this is a person passing away all of a sudden prior to age 50 with less than 5 years potentially, or 5 years or more, but they are not eligible to retire at this point. So they are in the pre-retirement stage. And with the pre-retirement survivor income, there would be a percentage of their salary that would be paid out depending upon their retirement tier. For the surviving spouse or domestic partner, their lifetime monthly income would start at age 60. However, if there are eligible children under the age of 18 or 22, if they're a full-time student or an adult disabled dependent, then that benefit can start prior to the spouse or domestic partner turning age 60. Then there is the last of the pre-retirement survivor incomes, where a person passes away, they do not have any eligible survivors. Then what would happen is there would be a refund of their contributions towards the pension plus interest will be paid out to their beneficiaries as listed on file. Last of the death portion of our survivor benefits is the basic death benefit. This is a one-time payment of $7,500 to your beneficiaries. You could see your beneficiaries at UC Raise. Also, it is very important to keep your beneficiaries up to date. And also, please check if you have retirement savings with Fidelity. You want to go to the Net Benefits website to make sure your beneficiaries are up to date at the Net Benefits website for your 403B, 457B, or your defined contribution plan. So when a retiree dies, what do you need to do? So I would say as soon as possible after a retiree's death, please contact us being the Retirement Administration Service Center. Our number is 1-800-888-8267. And you also want to contact Fidelity if you have any money in the retirement savings programs. And their number is 866-682-7787. When you notify the Retirement Administration Center, you will then receive a letter from RASC with the benefit information. Typically, it takes about 30 days during non-pandemic COVID times. Payment usually will begin 60 days from the report of death. So it is very important. Sometimes it can be longer, but that typically is due to the fact that people did not return their paperwork promptly, or for that matter, they did not provide all the documentation. So what is needed when someone passes away? We would need the name of the person, their social security, their date of birth, date of death, the date of marriage or state registration of their domestic partnership, whichever applies. Documents that you may need to provide can be faxed to the RASC, and our phone number is, or for that matter, our fax number is here, 1-800-792-5178. We would need definitely a copy of a death certificate, birth certificates for the spouse and or children, and if applicable, a marriage or partnership evidence. So it is very, very important to keep your information up to date at UC Raise. You know, a lot of these things aren't really pertaining to what we're talking about right now, but down at the bottom, this is where you will change your beneficiary information. And like I mentioned also, if you make any changes to your beneficiary information at UC Raise, that will not include your 403B, 457B, or DCP plan. So you will also want to go to the netbenefits.com website to make any potential changes there as well. So if you do have any more questions about survivor benefits, and I would say this, if you already retired, it is important to have your confirmation letter which states what your benefits are. If you do not have your confirmation letter, I would say please email me, and I could actually email that to you. My email is donald.goldberg@ucop.edu. Again, donald.goldberg@ucop.edu. Carrie has my information, so if you forget it or you write it down on a piece of paper and misplace it, no problem, contact Carrie and she'll contact me. Also, you can read up if you wish about the survivor benefits at UCNet. We do have a lot of publications. We have the survivor and beneficiary benefits for family members of UC retirees, and we also have one for active employees and former employees as well. And with that said, I'm going to, I'll say, make myself visible, and you'll have some questions for me?
Yeah, just stop sharing your screen there, Don. That'd be great.
Okay.
Thank you.
I will.
Well, let's start with questions for Don. These, thank you so much for that. Let's see, I'm going to stop participant sharing.
Okay.
There you go. Okay. And everybody, if you'd like, you should be at this point be able to do, let's cancel spotlight and everybody can do gallery view and we can all see each other. Okay, so on gallery view you can see each other. So Don, thank you for that. It's a good reminder for some, and then people, we have about 25 active employees on the today that will benefit from making those plans. If an active employee dies, does the divorced spouse get their share and beneficiary? If an active employee dies, does the divorced spouse get what would have been my pension share as the beneficiary?
I'll say I read that question. It was a little bit confusing to me. The reason why is it really depends upon the divorce decree. UC will honor whatever has been decided upon in that divorce settlement. So there is not necessarily, if a member dies and they're divorced, standard rules that apply. That all depends upon what was decided at the time of the divorce in regards to the retirement. So whatever was decided in the divorce, again, in that divorce resolution, that is what will be honored.
Okay, great. Pension benefits stop being paid to spouse when they die, not inheritance, correct?
Yeah, so basically it goes to eligible survivors. If you pass away and you have a spouse, then it would go next to the spouse. However, if you do have eligible children, including adult dependent child, then that person would be next in line to receive the 25% survivor benefit.
Okay, great. Would a spouse be eligible? Yeah, try to write, these sentences are hard to read. Would a spouse eligible survivor apply if you get married after retirement?
Gotcha. Yeah, well, I got you on that question. So to be an eligible survivor, you have to be, for a spouse to be eligible or a domestic partner to be eligible, the marriage or the partnership had to be at least 1 year prior to the retirement date. So they would not be eligible for survivor benefits if they, if this was after the retirement.
Okay, great. And if the spouse receives benefits, then dies, can the disabled child then receive benefits for their entire life?
Yes, as long as they are an eligible survivor as dictated by the plan, and if they are an adult dependent child who remains disabled, they would be entitled to eligible survivor benefits.
Okay, that's the questions that we received so far. Don, that was very clear. We'll be providing your slides to everybody. I did want to, I admire everybody hanging in there. We have quite a group here, but there were a couple more slides for Kristen that came up, questions that came up that I might try, that we didn't get to earlier. So I wanted to visit just define a conservator and a fiduciary.
Okay, well, a conservator is actually appointed by court. So there is a proceeding, and if and the conservatee, who would be the person who's conserved, would have legal representation or appointed legal representation in the proceeding. So you can nominate in your power of attorney or even in your Advanced Health Care Directive whom you might like as your conservator, but a conservator can only be appointed by court, and then there is supervision of the conservator. So it's a legal proceeding. A fiduciary is it's somebody who has a training and a certificate, and they act on your behalf. They're two entirely different things.
Okay, great. Can you have two trusts, one with your spouse and one personally?
You can have more than one trust. You just would have to make sure that the trust language in each of the trusts doesn't conflict. So, but yes, I mean, there are people who have many trusts and many different types of trusts.
Great. What happens if you appoint an executor, but that person decides they don't want to do it or maybe passes away before you do?
That was one thing I actually wanted to highlight is in this time of COVID-19, it's a good idea to just take a look at all of your estate planning documents. And also, as Ryan mentioned, you could have appointed somebody, now you're 85 and your spouse may not be up to the task, or people may have passed away. So it's a good idea to always to review and update your documents. But when we do these types of documents, we always have alternates. I mean, unless the person just doesn't want that. But I generally recommend having, at least two alternates to the primary, because you don't know what's going to happen.
Great. Any comment about Nolo Press? I mean, somebody has used this.
If you're asking, I mean, I guess to me is people, there are many different ways for you to do your estate plan. You have to do what's comfortable for you. I do feel like an attorney who practices in the area has expertise. If you want to avail yourself of that expertise, then we are here. And if you have ARAG, it's no out-of-pocket expense. One example I always use, because I've explained like the terms several different times, even during this presentation. I had a client who came in with a will. He was smart. He was not an old guy. He was young, still working in the tech industry. He left everything to his son and nothing to his daughter because he misread what a secondary beneficiary means versus a primary beneficiary. So these types of mistakes are easy to make if you're not very familiar with the language, and they literally could have catastrophic effects on your family.
Great. Thank you. I have a trust since 1997, but did not put my bank accounts on Schedule A. Instead, I put TOD on all of them. Is that okay?
Sure, you can always make TOD, and I don't know if this is the person I was corresponding with. Okay, so okay, yeah. So just let me explain it for everybody. We will frequently, like if there's a bank account that gets a lot of activity when somebody does a trust, we may say, yeah, just make it TOD and make the trust.
What does that mean, TOD?
Yeah, TOD or POD. Sometimes it's transfer on death or payable on death. So what that means is when you go into the bank with the person's death certificate, it is automatically distributed to either the trustee of the trust, if it's the trust, or the people. So, but there are considerations. How much time do I have? I don't want to take too long, but do I have enough time to make the answer complete?
Go for it.
Okay, so, but there are considerations when you decide to make something transfer on death. For example, if it's not in the trust, the trustee has no power over that account until you die. So if you want your trustee managing your account, or if you don't have your power of attorney, if your estate plan isn't complete, it means that account is outside the purview of the trustee until you actually die. So there may be a reason to put that account in the trust. I just don't know. Also, if you name people as opposed to individuals, if the person passes away, or if you name 3 people and one of them pass away, one of the downsides to a transfer on death is if it's like your 3 kids, you make your 3 adult kids the the TOD beneficiaries, and one of them passes away, what will likely end up happening is it's split between the 2 living beneficiaries, would not go to your deceased child's children, which may be what you want. So I'm just cautioning people, when you use that as an option, there are upsides and downsides, and you want to thoroughly think it through.
That's very helpful. Thank you so much. I'm going to go to a question for Ryan about Advanced Health Care Directive. How do you replace it and ensure that the prior directive is destroyed by a hospital or other medical provider?
It's a good question. If it's the same health system, most EMRs or electronic health records today will list everything that's all the documents that are in your chart, and so we will look at the most recent signed date. You can probably ask the medical record team to delete the old one, but at least when I've seen patients' charts who have had multiple directives, it's listed in chronological order with the newest one on top, and so we always use the most recently signed one. So if you do make a new one, it would be important to then share that with your health system and your doctor to make sure they have the most updated everywhere you get care. And then also all your family members too, who might have copies of your advanced directives, make sure they have the most updated ones.
Okay, great. And this goes to Dawn. Dawn, for survivor benefits, are they distributed to beneficiaries that are not dependents?
Okay, so we got lots of lists of survivor benefits. So pertaining to the pension, we have the eligible survivors, right? Spouse, domestic partner, children, or dependent parents. Then you name a contingent annuitant, that is one person at the time of retirement. Then the other benefits, including the death benefit, that goes to the beneficiaries. So beneficiaries are who you name, that can be changed anytime. It can be a trust. The pension portion of it is dictated by the plan, spouse, domestic partner, children, dependent parents, and then you only name one person contingent annuitant. So I would say it can be depending upon if you named a contingent annuitant or who is a non-family member, or for that matter, in your beneficiary designations, you have named those people, then it would go straight to them.
Okay, great. How is remain disabled determined?
Yeah, that is determined by the health plan. So they are the ones who certify the adult dependents as disabled or not.
Okay, great. And this sounds kind of specific, but how does this pension distribution work for an ex-UC employee with about 8 years of service?
Yeah, I saw that in the chat, and it still applies. It doesn't affect anything. If you retired, you made choices. You again, you could have a spouse, domestic partner, eligible survivor, and you could have a contingent annuitant that you name at the retirement. If you have not retired, and I'll say this, if you are over age 60, please call us, because the benefits continue to grow until age 60 as a former employee. After age 60, I cannot think of any real reason not to retire. So this is important. If you are over age 60, former employee, please call us to start the retirement. But if you pass away, you are still eligible to retire, assuming you're over age 50 with 5 years of service credit. So then it would go option A to your spouse or domestic partner if you have one.
Okay, so Don, of course, is a representative of the UC Retirement Administration Service Center. That has to do with your health insurance and your pension. We'll make sure you have that number. Ryan McMahan is a geriatrician that we've called in to talk today about health-related decisions and paperwork for that, and talking about having conversations with your loved ones. And Kristen is a lawyer, a estate planning lawyer, who has talked here today about getting your legal documents in place, of which include an advanced care directive. And so that kind of helps outline who's who of today. I have to say thank you to everyone for staying on today. If we have 5 minutes left, if you have a question, you're welcome to ask it. If you don't feel comfortable using the chat box and you want to just physically raise your hand like this, I'll just scroll through the pages real quick and unmute you to help you ask your question. And I can unmute you. I don't see anybody. I don't know, Chris, if you see anybody. And so can you please show the contact information, the contact slides again right now. Azita, each one of them has a different set of slides. Would it be okay if we email you all of those contact informations today? They all three have different slides. Okay, I'm going to assume that's okay. Just keep an eye out in your inbox and we'll make sure you get everybody's contact information after this event. Of course, we'll also have the event recorded so that you can look at the slides as well once that's recorded, and that'll be ready in a week or so. Okay, well, if that's all, we'll go ahead and wrap up. Let people take I really want to thank our speakers today. We're getting lots of thank yous in the comment boxes here. Excellent presentation and very timely given the nature of our time. So I really want to thank everybody today for if you know how to do the hand clap on your reactions, or just by the old-fashioned hand clap. Yeah, there we go. Thank you all very much. And so without further ado, I'll just go ahead and end the meeting today. And thank you guys again. If you'll email me your slides, Ryan, I will get those to everybody, and I have Dawn's. Thank you guys so much. Everybody have a good rest of your day and a good weekend. Thank you. Bye.